469279. Just call her Susanna. I can't pronounce the first name. Lozano Donohue and Jerry Donohue. Counsel, your appearances and bar numbers.
Owing Farley, bar number 8567, here with the plaintiff.
Morning, Your Honor. Joseph Knoll, bar number 8210, present with the defendant in this matter, Jerry Donohue.
Craig Burke used to be the attorney of record. Did you sub in?
Yes, I did.
Okay.
And I did notice the appearance.
Housekeeping?
Before we start, how was the New Year? I haven't seen this court before since the New Year.
It was good. Yes. And oh boy, I briefed this last week. Lots of paperwork that's been filed, reviewed the TPO court minutes. Apparently there was an objection. Mr. Burke filed to Judge Tootin. He heard it. Was the objection the fact that he didn't award him visitation time? And so Judge Tootin remanded it and gave him some visitation time? Is that correct?
Court's indulgence,
yeah.
1 second.
You can clarify that for me. And the other one was the evidentiary hearing to extend. That was Jillian Prieto that did that trial.
My understanding, Your Honor, was the objection was regarding the fact that the parties weren't properly sworn in and had to go back for properly sworn in testimony.
That was it?
My understanding.
Okay, and so Jillian Prieto did the evidentiary hearing. Was it for the extension? And I wasn't even
correct,
clear
Your Honor.
about her ruling, because the ruling was just, I'm going to put it over with Judge Moss on November 29th. And then Mr. Burke didn't file the OST, so it didn't get on our calendar. So I did some emergency orders, and how did the holiday vacation going? And has things cooled down between the parties? Or because we definitely have to address the TPO today.
Yeah, defendant was satisfied with the holiday visitation. And just for the court's record and for counsel also, I now have the video from the hearing. I'm having that transcribed today, so we'll have a certified transcript of that TPO hearing. I'll be supplying that to counsel, of course, as well as any relevant motions to the court. I'll be supplying that to the court.
Okay, so noted. It is Mom's motion and Dad's opposition, and there's a reply. Just give me the highlights as far as I understand all your requests, exclusive possession, custody, and all that, but focus on things that you want me to focus on.
Okay.
Okay.
Obviously, primary physical custody, we have not only a TPO, but there is still an open criminal case against Dad as a result of the domestic violence
Any
incident.
details? The judge, what the next court date is, pretrial?
My staff just looked it up today, and I don't have the exact details, but I know it just changed judges from one judge to another, and the next hearing date is set for, do you know it off the top? The 8th? 9th, January 9th.
Pretrial? Wednesday. There's a court date Wednesday?
Yes, and I'm not sure if it's the trial or if it's just a pre-trial preliminary hearing. I don't know enough about how to read the case history and the criminal cases to know what that means. But it is still pending. And I think the fact that both the police and the DA found it sufficient to pursue the criminal case regarding domestic violence should be more than sufficient for you to be cautious on intemporary orders and maintain the current order for primary physical custody with Mom and the current visitation schedule, which is pretty extensive. He has alternating weekends, and I think it's Wednesday evenings. And so
you did the trial with Jillian Prieto.
Yes.
Why is there a finding in the minutes, I didn't review the video, about Mom's credibility? I want you to give me your perspective on that.
I think it would be interesting if you were to watch the video or read the transcript.
May just, yeah.
I think it was, I think that finding is odd and inconsistent with the evidence. That's my personal opinion. After being there, I think that there were very clear situations where...
The reference was there was a prior incident, like the night before, nobody got arrested, and then the subsequent incident, Dad got arrested. And it had something to do with Mom's credibility. Okay, well, I'll watch the video for sure.
I think that might be helpful because, to be honest, I don't know why, and I don't think there was something obvious to anyone but Ms. Prieto as to why she would find the credibility issue on that side instead of the other side.
I'm assuming you're requesting assessments or some type of custody evaluation if they can afford it?
I guess that's kind of up to you And so if you, Mom doesn't work right now. Dad is claiming that he has negative income from his law firm, which I'll go into in a bit.
Read all that in detail and about the 73,000, the 80K or something like that, right?
So if he wants to pay for a custody evaluation, obviously my client can't pay for it, but if that's what you want done, my client would certainly be happy to comply and have someone looking into this in more detail. It's just whether or not he would pay for it is the...
You want a business evaluation as well?
Yes, I want a business valuation that both looks at the value of the business for community property division, but also his income for spousal support and child support purposes. So for the business valuation to come up with to answer both of those questions.
What would be the pros and cons of exclusive possession of the house?
Exclusive possession, number one, she's been living there since August. The children have been living there since August. We certainly want to maintain stability for the children.
It's a separate property?
He
or
keeps saying it is. He still hasn't provided me with proof sufficient for me to think that that's a done deal. So that issue is still outstanding.
Does she have family in town?
Is she?
If she were to move somewhere else?
No, she doesn't have. She doesn't have any resources or ability to move anywhere without him paying for all of the moving and everything. And so I don't think that it's really appropriate for a temporary order to move her out now if there's a chance that she may well stay.
Eventually, though, she won't be able to have the credit to refinance the house or purchase the house from him or vice versa? I don't know.
I don't know. It depends. I guess, if there's a huge value to the business and there's a community property house, maybe that's an easy answer, but we're not anywhere near there yet.
Do you think it's premature at this moment?
Yes. Yeah, so I think we just keep things the way they are.
Where's Dad? What's your understanding where Dad's living?
It's my understanding that he has been hoping he'd get back into the house and therefore has been staying at his office, and when he has the kids staying at a hotel. If you were to enter an order for exclusive possession today, hopefully he would go and get an apartment or something so that he has some stability for when he has the kids. And those.
Is there any issues with like silver bars, gold bars, or property?
Yes.
What's your request on those?
There were 8 100-ounce silver bars that were left at the marital residence that my client has brought into my office, and I have them in a safe deposit box right now that my office has opened. And as far as attorney's fees requests go, my client has used a bunch of credit cards and has emptied her retirement account in order to pay for living expenses and attorney's fees to date. She really doesn't have any other options for how to continue to pay me or how to continue to pay living expenses unless we have an order from you today. But so my request as far as attorney's fees goes is that my office be able to cash in those silver bars and utilize that money for attorney's fees.
What's the number incurred and what's outstanding in terms of fees?
I do not have those numbers off the top of my head, you know.
Rough numbers. As far as her billing?
I don't know the incurred and outstanding. I think we're about even right now as far as her having been able to pay.
Are we into 4 digits or 5 digits?
That's a good question. If while he's arguing, I'll text my office and see if I can find out by the time I give
Good
him a
enough.
reply. But because we're going to need to look at the future, what I need to do in the future, I guess, is what I was focusing on for today, because we're at least covered sufficiently for what's already been done. And so what needs to be done in the future, the big issue is that we have this law firm, and he's claiming he has negative income. I've already conducted depositions of both the defendant and his paralegal. I ordered bank records because those were not being provided to me. I've gotten enormous amounts of bank records, which I have gone through those to some extent already and found, I think defendant and his counsel will agree, found where his paralegal's been embezzling from him. There's a lot of stuff.
Is that a request that Jamie
records.
Clark stay away from the kids?
Yes, that would be wonderful. So there's a ton of documentation that I have to go through.
Do you have official evidence that she's been charged?
She has been charged. There are 2 cases pending against her. One, my client is the victim of.
Downtown District Court?
Yeah, one of them has been transferred to district court, and it appears she may well be entering a plea in that one, and that's the one where there's a client.
Transfer, you mean bound over?
Yes.
Okay.
So she's been bound over for trial from justice court to district court in the case where there's a client of the defendant's who's the victim in that case.
Saw the letter that Shelley, or what's her name? Female, I know that.
Stephanie Bowie.
Stephanie, okay.
And then there's another open case that's still pending where my client is the victim as well. And both of those are still active, open criminal cases as far as I was aware 2 weeks ago when I did the depositions. And so I believe they still are. And
the DA filed on her behalf as a victim of what?
Of identity theft.
Identity theft.
It has to do with use of credit cards.
Read that. What about their claim that she self-inflicted her bruises and stuff that she took photos of? And do you have the original photos, by the way? They never scan in that well.
Right. I don't know if we have the original photos today with us in court, but I think she still has some on a camera. Sure. She's brought me a camera.
But what is the claim that she self-inflicted those wounds?
Number one, I mean, these are photos that we have spanning a long period of time. And we also have journals that has documented abuse over a very long period of time, enormous amounts of writing, and only certain amounts of it document abuse in these handwritten journals that she has. But she has.
If you're going to use those for trial, they have to be completely translated into English.
Yeah, I understand that. There's so much in those, and I think just the fact that we have her journaling over year after year after year.
Well, you attach them. I mean, I read a little Spanish myself, but they have to be translated, so I can't rely on them unless they're actually translated.
And at this point in time, I think more the point of the journals is that obviously she didn't go in and write 5,000 pages, I don't know how many pages they are, of handwritten journals just in preparation for this case. This is something that's been going on for a long time. The photos all have especially the ones on the camera, when they were taken. We have a time, long time periods of documentation of this abuse, and unfortunately she stayed with him when maybe she shouldn't have for a long time, but a lot of people do. And certainly, she absolutely maintains that the bruises were caused by him. All of the evidence that she's bringing to you to document domestic violence that happens is absolutely legitimate. I have voice recordings of the defendant. Some of them were played at the evidentiary hearing. Some of them were played at the deposition. I have the recorder with me if you'd like to hear them. But voice recordings of him, the most notable one where he says something to the effect of, "I am going to bury your body in the desert so no one can find you." It's on tape. I believe at the evidentiary hearing he admitted that was his voice.
So your motion had a photocopy of a CD. Next time, counsel, both of you, if you file any CDs, that you send the original, a copy of a CD in my mailbox and flag it down and point it out to us that is something that, because I didn't have time to review that. Okay, what's your laundry list of what you're requesting? Then I'll go with Mr. Nold.
Okay. So, primary physical custody, absolutely the same visitation schedule that we have in the temporary orders right now. Joint legal custody, child support, and he claims on his FDF that was just filed that he has negative income. I don't think that's true. I think he has significant income that's not being put through his bank accounts, not being put through proper channels, and that he has the income sufficient to warrant a capped child support award. He's an attorney. He's been an attorney for a long time. He has the ability to earn good income, and if he's not, it's because he's preparing for this case. So I'd ask for the cap, which I think is $2,080 right now for 2 children. Health insurance, we'd ask that he be ordered to provide health insurance. He has a greater ability to do that. And
what do they have now in terms of health?
No health insurance for the children.
Did you get some numbers on how much it would cost?
No, just whatever basic plan he can get that's sufficient to at least have some type of insurance.
Okay.
And then the 30-30 rule for medical expenses, of course. Spousal support, obviously he's claiming negative income, and like I said, I don't believe it. There are community expenses. He's been the sole provider for this family for a long time now, and has been paying all the expenses as community residents.
What's her need?
Together.
What's the number?
So what I would ask for is that he continue paying all the household expenses on the marital residence, including internet, which is needed for the children to do their homework. So all the household expenses that they've already had at that residence, plus $1,000 a month for food, gas, all those extras. But also she has these credit cards that she's racked up for her living expenses and attorney's fees to date. So I'd ask that he also be ordered to pay the monthly minimums on those credit cards in addition.
And how much is that?
she's not 100% sure, but it could be at maybe $500 or more for the 3 credit cards that have balances on them right now. So all household expenses, monthly minimums on 3 credit cards, plus $1,000 for the food and those kinds of spending. Certainly ask for exclusive possession of the marital residence, maintain stability for these kids, and not move things around at this point. I'd ask to extend the TPO for 1 year. There's a pending criminal case. I think the fact that there's a pending case is more than sufficient for you to extend a TPO to the extent possible. There have been continuing communications and issues, although the communication and the problems have been significantly less than the TPOs in place, so I think it's been very useful to have it in place. But even with it in place, he has still attempted to contact her to reconcile or to try and settle. I think if it were to go away, his attempts to control her and try and get her to do things would...
I may have read somewhere that she's also contacting him. Does it have to do with children issues only, or?
Yeah, there've been communications regarding the children, and I think, actually, you know what, when you asked about the credibility issue that Credo mentioned in the minutes, I think that actually is what she was referring to, that my client has contacted him, he has contacted her, and you know, I think Ms. Credo thought that indicated that she wasn't afraid of him. I don't think that's true. I think that was an improper analysis of why she would be communicating. I think my client wants to do the right thing. She wants to communicate. She doesn't want, you know, and since then, you know, he'll send her an email, and she'll email me and say, should I respond? No, you shouldn't respond. But it's, you know, her instinct is to respond and to interact how people interact. So I think it's been very difficult for her to know where that line is, especially when he is initiating communications. He's a lawyer. He knows how these things work. He's certainly in a better position to be expected to comply with the law 100%. He's also the adverse party in the TPO case, but she doesn't want to have communications with him, and she would really like for the TPO to remain in effect so that he doesn't try to get at her in the ways that he's been doing already. I think it's a clear case where there's a huge imbalance of power, huge imbalance, and it's something that's been taken advantage of, and we need to make sure that these parties don't have that communication that could be very detrimental to my client, both mentally and...
Other requests?
So the attorney's fees to be able to cash in the silver bars, the 800-ounce silver bars, the value I got online was about $3,000 each. So I'm asking to be able to cash in all 8 of those approximately $3,000 each valued bars to cover attorney's fees, the business valuation for income and business value purposes. And I would suggest either Steve Nicolatis or Richard Teichner to do that. And for him to pay for that valuation and get it set up within a certain time frame, possibly 5 days. And as discussed earlier, if you want to do a custody evaluation or something like that, I'm certainly open to it as long as he's the one paying for it. Thank you.
Mr. Knoll.
Your Honor, I'm going to try to be brief. I just don't know where to begin. I've read through all of the relevant pleadings for today.
Just curious why you changed attorneys. Well, Mr. Burke used to work with your firm, didn't he?
That is correct.
Okay.
And both Mr. Burke and myself have went to law school with this gentleman, so we go way back. Which, again, I do not bring my personal experience in here. I stick to the evidence. However, Your Honor, a review of the pleadings, and I never joke with this court, I don't mean this as a joke, portrays this man to be the devil. I believe that that's why the TPO hearing master found some credibility issues, just because of the onslaught of allegations against this man. Again, that's why I'm getting that transcribed for you. But let's look at what we're here for today. Temporary custody is linked with, or the temporary orders for custody are linked with the TPO hearing. There are allegations against Mr. Donohue. There is a criminal case pending. That next hearing date is on the 9th. That will not go forward.
Is it pretrial?
No, that was supposed to be the trial date. It will not go forward, though, because what Mr. Donohue's, for the record, what Mr. Donohue's criminal attorney is doing is he's subpoenaing the police records because there's a assertion that they were out the night before. And again, apparently, if you're out there twice, and the TPO hearing master even referenced that, you were out there twice, so I'm going to extend it until the 29th of November, which obviously got extended to today. My point is that, Your Honor, the evidence that is used against him is the statements of the plaintiff only. That is the evidence against Mr. Donohue for the TPO hearing. It's a rebuttable presumption, even if he's convicted, that joint custody is not in the best interest of the children. Your Honor, we haven't got to there yet.
How fast is this case going to get resolved?
As soon as the state complies with the subpoena that Mr. Donohue's attorney put over there. That's a question, unfortunately, Your Honor, I cannot answer. I don't think the criminal attorney can answer.
Who's the judge on the case?
Your Honor, I think at this point it's going to be Ms. Tobiasen, Judge Tobiasen.
Oh, Melanie Tobiasen?
Apologize, I didn't know that, Your
So
Honor.
it could be a couple
My
of months,
point
it
is-
could be in the summertime when you get to trial and then get a decision on it.
I mean, obviously, we don't want the TPO going forward, and here's why. Mr. Donohue is currently getting his books for his business done. Within 30 days, we'll have 2011 done, and as soon as thereafter, we'll have 2012 done. First, the bookkeeper's got to do it, and then it's got to go to the accountant for the actual tax filings. Again, we're very confident within 30 days, we'll have 2011 done. It's going to show from 2011 and 2012 a loss of anywhere from $10,000 to $15,000 each year. The question the court should have then, any normal person would have is, well, how have you been making it? How have you been getting by? Well, Mr. Donohue, earlier this year, last year. Yeah, last year, earlier in 2012, before the divorce started, had taken out his retirement account in full. That's how he's been funding and paying for the marital bills. Mr. Donohue did have a large inheritance, which plaintiff is well aware of. He took that bulk money, bought a house. That was $80,000. The $70,000 or whatever, $73,000, whatever is referenced in a separate property account, that is down to approximately $38,000 or $37,000 at this point of separate property money.
From some property that he sold in...
That is correct. He inherited from his last
Arkansas,
living grandparent. He inherited his, for lack of a better way to put it, his boyhood home in Arkansas.
Yeah.
He sold a small portion of it and some timber, got money in. And again, he's been using his separate property money to support the community. My point is, Your Honor, first of all, regarding custody. I understand the court's going to do temporary orders today, because this is linked with child support too. We would ask for more time for Mr. Donohue.
He's getting every other weekend right now.
Correct. At least every weekend then. I understand the court is not inclined, and I warned Mr. Donohue walking in here to give him joint physical custody at this time because he is working full-time. Your Honor, respectfully, we didn't brief this, but I think it's relevant for the court. The children are in school. Plaintiff needs to find a job. Mr. Donohue is losing money. Again, I'm kind of jumping around, but it's going to all come together here.
Yeah.
At my suggestion and demand, Mr. Donohue has redone his resume and is trying to get a better job now. He has been his sole practitioner for a while. His business is losing money. He has Ticket King and Jerry Donohue Criminal Practice. Well, because the pending TPO, or the pending criminal charges, he can't get a job with the prosecuting attorney's office. He's an ex-prosecuting attorney.
Yeah.
He can't get a job as a public defender's office. As this court is well aware, most practitioners in criminal law are sole practitioners. So he's trying to find a job, and he has no experience in civil practice.
How long has he been in solo practice?
Mr. Donohue? I know since 06, because you came into my building then, right?
Around 2006, Your Honor.
Yes.
Okay. And prior to that, you were living in another state?
No, Your Honor. I had worked with the Clark County District Attorney's Office, and then I worked as a public defender for the city of Las Vegas, and then shortly, sometime after that, went out on my own.
What about applying with other criminal firms?
I don't even know of any criminal firms. They're all solo practitioners, as far as I know.
Oh, really?
There's the big firms, but again, thank you.
Yeah.
My point is that, Your Honor, we're going to be the only winners in this case. I hate to say it like this. They're going to be the attorneys because there's no money here. There are some silver bars. There some separate property money. They want a business evaluation, fine, but our representation, it has no money. Custody. We would ask for increased timeshare, something so Mr. Donohue can stay more time with his children. Right now, he is living in his law firm trying to save money. He doesn't have the money to go get an apartment. Fortunately, there's a shower there, don't get me wrong. And when he has the children, he gets a hotel room, so they have a safe and secure place to be with him. The house, again, is separate property, but I don't have the documents for you today. I'm getting those together, and we anticipate within a week to have the appropriate motion before you. Child support. Your Honor, the bank documents are in the possession of plaintiff. She subpoenaed them. We've supplied what we've had. There's nothing before you to show you that Mr. Donohue's affidavit is not accurate. It's financial disclosure form.
Does he take a $3,000 draw every month from the accounts receivables?
Stand up and explain to the court
It's
how
usually
much you've taken in
typical, I
draws each month for the last 2 years.
It's listed on his FDF.
Your Honor, I haven't had a paycheck since 2010. I haven't taken any money out of my company since 2010.
Do you use your company monies then to pay most of your bills, like your meals, and do you write those off? Your car, your
Company
gas?
expenses like bills,
Yeah.
like meals,
No.
gas.
No, I don't use...
Check his FDF. Did he not list draws as far as...
I will double check that. I will double check that, Your Honor. I
I
apologize.
saw a draw somewhere. I saw it somewhere. A lot of paperwork filed, but
As far as
he's not taking draws.
Correct. As far as the need of the plaintiff,
And the bookkeeper does your P&L statements every month? And
I just hired the bookkeeper about 2 or 3 weeks ago.
prior to that, you never had P&L statements monthly and yearly?
2010 was the last one I had, but I hadn't done 11, so that's what I hired her for, was to do 11.
So you did everything as far as the accounting then, with your business and
Previous.
general accounts, trust accounts, and all that?
Previously, yes.
Okay.
as far as the need of the plaintiff
Yeah.
for, right now, child support and spousal support, I'll note on her FDF, she's showing expenses of $10,000. The house is paid for. She pays no mortgage. She has $1,000 there. Attorney fees, she has $3,000 a month. Credit card payments, she has $4,500 a month. My client fills up the car with gas. I don't know where these expenses are coming from.
Question, does he use his house to run a business out of it too, to take deductions?
No, Your Honor, to the best of my knowledge, no.
He's never done that.
No.
I thought that might have been one of the reasons why you want to get back in for exclusive possession.
Being straightforward with Your Honor, no. I know I
He
would
wants
like...
back in, where's she going to live?
And I've explained that to my client. We've got it, and that's why we're asking that if exclusive possession is not warranted today, let her stay in the house. And if it is, it should just be temporary until we get the appropriate motion for you. Unfortunately, Your Honor, I'm a little bit behind the 8 ball. I'm not making
Yeah.
an excuse that I came onto the case. I'm organizing everything. But when I come in with a motion, we're going to say, Jerry should have the house, and here's where plaintiff is going to go, and here's how it's going to work. Here's something
What's he
for this
paying
court.
out of pocket? Is he paying a mortgage? Is he paying
There's no
utilities?
mortgage. It's paid off in full from his inheritance.
No mortgage, okay.
Yeah, there's no mortgage on it.
Who's paying the utilities, internet, cable, phone?
Stand up.
Your Honor, I get all the bills sent to me except for the internet, but I pay all the bills, the gas, the water, the electricity. They're automatically debited out of my account that my inheritance money
Okay.
is in.
All right. How much does that run a month?
I don't know. I tried to put it on my FDF, several hundred.
Why is the internet not in your name?
I'm sure it is in my name, but I'm not getting my
The bill?
mail, so I've never seen a bill.
Have you checked on the account lately?
I don't know what the account
Is
is.
it Cox Cable or
No, it's
CenturyLink?
It's
Who does your internet?
Cable or
it's-
satellite?
remember who it is. It's
Okay. Well,
DSL, whatever DSL is.
that's phone.
Okay, it's
That's the
phone.
phone.
Yeah.
My point is, Your Honor, my client is using separate properties money now to support the family, and again, I've explained to him, and he's not going to like this, that he's going to have to do this for the temporary period, but requests for child support of over $2,000 a month, spousal support in a large amount, when plaintiff's not working and the children are in the school, Your Honor, that is inequitable in all aspects. The parties should also go to mediation regarding a reasonable timeshare, as this court usually sends them over.
Downstairs or private mediation for all the issues?
No, just the downstairs for that. Again, I'm looking at the cost here, Your Honor. The business evaluation, we will open up the books, anything that they want. In the motion, it also asks for a receiver. We have a sole practitioner who's losing money, Your Honor. This is a waste of the limited resources that we have.
Okay.
The silver bars. My client did buy 10 silver bars. They're in the possession of plaintiff in the marital home. Now, apparently in her counsels, but she said only 8. So we'll have to check on that because they're serial numbered. If they're gone, we'll report to the police that 2 are missing. Your Honor, I would request right now, notwithstanding, again, my client, I can hear him already, he's mad about this.
Does he want to buy the bars back from her?
Well, they had agreements going back and forth, and he actually thought that he'd already bought 3 bars because they split him, then he gave her money. I explained to him, which he does not like, and I'm saying it for the courts, for him really, that community property laws in Nevada don't work that way. This happened during marriage. There's nothing in writing. This is community property.
She can trace the
funds at this point, we would ask that half the bars be brought to my office. I will give them to my client. She can use the other half for attorney fees, whatever she wants. My client has paid the statutory minimum for child support, which is $100 per month per child. Again, there's nothing on his financial disclosure form to show that he is lying up to this court about anything. The credibility issues go against plaintiff, respectfully, from the TPO, the only fact finder that have looked at anything.
Is that the pending order? Is there a pending order for child support?
No.
No, there was no
Nothing
child support
whatsoever?
order in.
Okay. And what is he proposing?
The statutory minimum, and we'll allow it like this, Your Honor, the statutory minimum, subject to retroactive modification. If they show this man's lying, hammer him. But he's not. He's telling you he has no money. He is being honest, Your Honor.
His pending case, he's still able to practice, right?
That is correct. He is not precluded from the practice law.
Even appearing in Tobiason's courtroom?
That I can't answer. I would assume
Okay,
there may be some type of conflict on there. And also, Your Honor, my understanding is, and I've represented several attorneys in the past, even if he was convicted, because it's a misdemeanor, he can still practice law in Nevada. But he's precluded from being a prosecuting attorney or a public defender with any conviction and the gun rights and all of that.
Yeah. And how many pending cases does he have now, as far as business-wise?
See, that's difficult to answer because he has something called Ticket King. And there they get anywhere from 5 to 10 tickets a week, if we want to call those cases. Mm-hmm. Then his criminal practice is not very busy because he cut off his advertising, and he's relying on word of mouth and repeat business.
Been around doing it for 6 years, though. Don't you think he can build up that business?
Somewhat.
Right.
But again, that has gone downhill for the past 2 years.
Is his practice mainly misdemeanor cases? Does he do big felony cases?
And I'll have
murder
the client
trials?
answer. He's in a better
And
position.
usually those types of cases, you get your money up front, so these clients pay you.
Your Honor, just me, I have no felony cases at this time. I only
Okay.
have a handful of misdemeanor cases.
Right. And then the tickets, you do the tickets?
Right, $50 a ticket, right.
Right. Okay.
The request, again, let's
You're
go
not a
through it.
contract attorney, are you also?
I am not, Your Honor.
Okay.
No.
Let's go through it. They're requesting primary custody. We'll defer to what the court wants. I understand there's the criminal charges pending. We don't want the TPO in place. I understand, and again, I'm not going to argue something I know this court is not going to do, which is dissolve immediately without any restrictions the TPO with a pending criminal charge. I'll defer to this court's discretion on that, noting credibility of plaintiff
How
on
long
this
has it
one.
been in place now?
Your Honor, I'm sorry, I misspoke. I may actually have one felony case. It
Okay.
just popped in my head.
Okay.
I'm sorry, I misspoke.
Is that 7,500 or has prices gone up? I know felonies cost more. What do you charge on felonies?
I think I quoted him 4,000, but I'm not positive of what I quoted. Yes, 4 is what I quoted him.
Okay.
When was the TPO first in place?
I was served the TPO as I was being released from the jail, so approximately August 5th or 6th.
Been going on since August.
Yeah, so we have 4+ months on it, Your Honor. Again, I would assert to this court, without any hesitation, that Mr. Donohue, and in no way, and I don't believe there's any allegations, is a threat to the health, welfare, or safety of the children.
Did it come out at the trial that she was, well, you can't violate your own TPO, but was she contacting him?
There was a reference, there was an admonishment by the TPO hearing master at the end of it, letting the plaintiff in this case know that if she does contact him, she would, for lack of a better way, I'm paraphrasing, will be pulled on the carpeting in that court, and the TPO hearing master directed Mr. Burke to file the appropriate motion if plaintiff did contact him. My client hasn't informed me that around this time period, he believes afterwards, plaintiff showed up at his office and cursed at him and yelled at him. we have no...
What about those voice recordings they have?
And again, that was played during the deposition, Your Honor. I'm quite frankly, again, I've known this man for 12 years. I could not understand what was being said. I'm just being honest. I think that would be appropriate for an evidentiary matter. Again, we'll do this case right before the trial. We will file the motion.
There's nothing in English that says I'm going to bury you in the desert?
Again, I'm being honest, as an officer of the court, and again, I said this in the deposition, I could not understand what was being said. I believe it was a battery problem also at the deposition. They had referenced the low battery on it. I haven't heard it. My client says that he didn't say it, and if he did, it was in the heat of passion because he was angry. Couples fight. They're yelling back and forth. Again, I don't know, Your Honor.
Did he send emails or texts that says, if you want war, we're going to bring it on, we're going to go to war with the kids and everything? Was he angry when he said that or sent those in writing?
You know the email she's talking about?
I don't. I think the email says something along the lines of, please don't start a war, that nobody survives wars. Don't make this a war. I believe that's what the emails will say.
I think they said, if you want a war, we're going to have a war.
Again, Your Honor, I will...
Did she make threats to him, too?
Your Honor, what testimony did come out, and I believe from the next-door neighbor at the TPO hearing, is through the course of this relationship, Mr. Donohue he's lived there for how many years next door?
We've been neighbors for 13, 15 years.
Okay, long-time next-door neighbor, older gentleman, said never heard Mr. Donohue raise his voice. He never heard him being aggressive, that if anyone was the aggressor, and I'm paraphrasing, it would have been the plaintiff. That was my understanding of the testimony heard by the TPO hearing master. Again, that was, I believe, in my opinion, part of her determination of credibility going forward on that. You know, you hear everything, and this man, again, doesn't have horns out of his head, but they're saying he does. And the evidence shows something different.
Well, one night the dad didn't get arrested. They handcuffed him in his back, made him sit down so he'd calm down. What was that about?
That would, and again, Mr. Donohue would be better said as a criminal attorney. That is general. When a police officer walks in and there's a party there, to put someone in restraints is standard operating procedure. As a criminal attorney, I think Mr. Donohue can comment on that.
It wasn't because you were loud and...
No, the police, Your Honor, I'll just try to be brief as I can. I was playing with my little girls, what we call luchitas or wrestling.
I read that.
Next thing you know, the police are coming in.
She was upstairs trying to give the other kid a bath.
No, I think
it was a different incident.
He was right, but the police came in, and the children ran off scared into the back bedroom. The police officer put me in cuffs. I asked why he was doing it. He goes, "This is just what we do. This is for officer safety," is what he said. Both parties were questioned. The officer came back to me and said, "She's completely nuts. Nobody has ever called the cops before over somebody playing with their children too loudly."
You want to get an officer to testify to that at our trial here?
I don't know if the officer would remember saying that or not, but that's certainly what he said. He goes, "I've never seen anybody call the police over a father playing too loudly with their children."
You're saying she set him up?
She called the police because I was playing too loud with the children. She told me to be quieter and quit, and I said, "No, we're having fun." And 10 minutes later, the police are walking in my door.
And the night, Mr. Thank you.
There was, in one of those incidents, they both wrote statements.
Yeah, and the subsequent one, which is the one that he's being charged with, that's the one that happened in August. The officers represented to him that they were out there the night before. He didn't know anything about that. What am I being arrested for? Again, Your Honor, best dealt with the criminal one. For right now, what I'm saying to this court, without hesitation, there's no even allegations that he's a threat to the health, welfare, or safety of the children. He loves his children more than anything. This case is going to be a custody battle. The finances are going to be what they're going to be. The only evidence that he's a threat to the health, welfare, and safety of the plaintiff is her own testimony, and a fact finder has found credibility issues. We would ask, and again, we'll defer to what the court wants. I'm not going to over-argue this, Your Honor. Whatever the court decides is best. I know what is standard on this, but we also have to take in consideration that Mr. Donohue, for many years, notwithstanding these allegations that he beat her and locked her up and hit her and did this for 12 years straight, the police were never out there and never did anything. All of a sudden, comes time for divorce, he's Satan.
How old's Ananda?
She is 7 now, Your Honor.
And Fabiana?
She is 6 now, Your Honor.
Okay. Very good.
There seems to be some reference on journals. I'm going to put this on the record right now. I've already contacted our expert on this. Your Honor, and I know the court actually referenced this, which is regarding these journals being prepared for this trial. We believe that they were all recently prepared.
Recently prepared.
Yeah, we're getting an expert on this. As soon as we can, we will be requesting that he look at the originals at opposing counsel's office.
Yeah.
Great.
Okay. What's your list? What's your...
Your Honor, more time for my client. We will defer to what the court wants temporarily, then they go to mediation. Child support, statutory minimum, and we will volunteer that it be retroactive, and with penalties and contempt against my client if he's found to be lying about the money issue here. We request that plaintiff be required to get employment. Children are in school. She could work and put forward a reasonable amount of resumes or interviews or contacts. My client will voluntarily offer the same. The firms he's contacting, doing things like that. Spousal support, $1 a month, subject to retroactive modification. My client just doesn't have the money, Your Honor. We understand the marital bills have to be paid. Order my client to pay them. I understand we've got to look out for the children. They need food, shelter, water, everything. I understand that.
What do you believe Mom's capable of working, and how much can she earn?
I would say she's capable of making at least $10 an hour.
She's clean houses, isn't she?
Yeah. $10 an hour is what I would find.
Right. All right.
Again, I know times are tough. Again, dissolving the TPO, as far as exclusive possession of the home, we would ask that the court at this time only enter an order for status quo. It's a separate property, but I have to come to you with a game plan. And I've explained that to my client. I've got to show you how the children and the plaintiff are going to be taken care of and how he is. Your Honor, we have just received the documents, and counsel will be getting the 16.1 production for all the tracing of the money, from the trust in Arkansas all the way through. But, again, I'm
The house is paid off, so there's not going to be any MomQuest calculations,
Correct.
is there?
Correct.
The only thing you can get back is improvements.
If there were any, yeah. And on that issue, there is one thing, and I spoke to counsel. She didn't want my client out there. There's a swamp cooler out there that needs to be winterized. My client volunteered to do it. He just needs to get to the garage and get some tools. Doesn't have to come in. They said no. We just asked that the plaintiff be ordered to take care of that. Again, we don't want a $3,000 or $4,000 swamp cooler to go under when you need to winterize it. I don't know what the cost is going to be. It takes about an hour. Small issue. We tried to work it out. It didn't work.
Technically, Your Honor, it has to be drained, dried, and painted, just so it doesn't rust.
Yeah.
How much would a handyman charge?
Probably more than the cooler itself is worth, would be my guess. The coolers, you can buy these coolers for $500 or $600.
I thought they were more expensive. I apologize. I thought it was more expensive.
You're willing to do that?
Do it in an hour or less.
1 hour. Okay.
Doesn't have to get inside the house. Again,
Other
just a little
requests?
small issue. So
Right.
they're asking for attorney fees, Your Honor. At this point, again, Sergeant Case, well, my client, right now before this court, there's nothing to show that he's not losing money and hasn't lost money for 2 years. We would ask that the silver bars be split. And again, I'm being as straightforward with this court as I can, subject to retroactive modification. If you find this man's lying, hammer him. But he's not. He's telling the truth. What they're asking for is him to take his inheritance from his last living grandparent and give it to them. And that, Your Honor, that's inequitable on many levels.
What's he going to do with his silver bars if he gets some of them back?
That I have no idea, Your Honor. Being honest, I never, before this moment, I didn't even think about it.
You can't.
I mean, they're asking for money, so we're saying, okay, split the bars.
Dispose of them or sell them.
Well,
Unless there's court permission or stipulation by the parties.
Well, if this court was to order that each side gets half the bars, and then that's your sole and separate property to do with it as you want, I think that would be appropriate. Then if Mr. Donohue needs to, I know.
Okay.
If Mr. Donohue, you don't have anything ready. If Mr. Donohue wants to sell it, keep it, whatever he wants to do, I think that should be separate property, half and half.
A little bit pressed for time. I've got 2 more 10:30s, so I can give...
Your Honor, that's,
Yeah,
as far as everything they asked for, that's basically it. We don't care about this Jamie not seeing the children. She doesn't see the kids anyways.
No objection?
No.
Okay.
And she works there because Jerry can't get another employee to do what she does for what he pays her.
Even despite these, you're not aware of any pending charges?
Well, no, as far as that, at the deposition, Jamie has, I was there defending the deposition, or there at the deposition for
Yeah.
her. She had stated that the state was going to dismiss the charges of plaintiff against her. I didn't
For
check
the
on it.
identity theft? And then the
The
other lady
identity
was a
theft one, she said she
Stephanie,
was going to plead out, and I don't know the status of that.
and the Stephanie, your former client, Stephanie
That's
somebody?
that's the plead out one she's doing. My
Okay.
understanding, again, 2 criminal cases, one of the plaintiff against Jamie, she said that one's being dismissed. The other one
Did
is
they
this,
imply that Jamie Clark has some kind of history, also a prior history?
and she does. And she does. But my client has, since all of this came up,
He knew about the history when he hired her?
no, this has
no?
recently come up. And since that time period, he's stuck right now. He has somebody that has to do this job. He can't get anybody else in. So he's taken checkbook, access to anything that he thinks would be dangerous.
Away from-
She's basically only dealing with Ticket King now. You take the money in, you staple the receipt to the ticket, and the money that came in,
Yeah.
and he gets it every single day. That's it. You don't touch anything else.
And she answers phones for you?
Until he can get her out of there, but he doesn't have the money to hire anybody else. She's owed thousands of dollars of back pay. Another story for maybe an evidentiary.
In other words, she'll be phased out?
As soon as possible.
Got it.
As soon as possible.
Okay.
And as far as that, that's it, Your Honor. We'll
Thank
just
you.
most of it we'll just defer to your discretion. Thank you.
Okay, and they have counter motions, so just 2 minutes apiece, and then I'm going to make a temporary ruling.
Okay. Just on credibility issues, Mr. Donohue represented Jamie in one of her prior criminal cases. He was her attorney of record. He obviously knew about it, and there was other cases before that which you would assume as her criminal attorney he would have looked up and known about too. He also had a bar complaint that was filed against him by the state bar regarding Stephanie Bowie, the victim in one of the cases, and
We don't have a resolution on
fired
that.
Jamie and informed the state bar that he had fired her, and then hired her back again, and she is currently still working for him. So there's a lot of weird stuff going on with that whole issue. I don't want to go into it a lot.
Give me an update on that bar complaint. Mr. No may want to speak on that, but go ahead.
And then also the 2 cases against her, the DA says that they're not dismissing one. So there's a bunch of odd information regarding all of that. But
But they don't object to the no contact order on a temporary basis.
So as far as their request to split the silver bars instead of have them all go to her, he has, I don't know what the current balance is, but as of a month or so ago, $70,000 in the bank. He doesn't need to cash in the
Because
silver
it's down
bars
to
in order to
38.
pay his attorney and pay his living
I'm
expenses.
assuming you're going to get an accounting for that also, right?
Absolutely, but he does not need the money cashed in from the silver bars. He has way more than half of the liquid funds. He has the real liquid funds right now. So absolutely, I think that would be unequal. If we're going to say 50-50, 50-50, split the $70,000 and split the silver bars, great, that'd be wonderful. But the easiest solution, I think, is just to let us cash in the silver bars that we have right now. I think that hopefully will be sufficient for us to go in and do enough discovery
What about
to figure
work
out
for
what's
Mom?
going on. Huh?
Work.
Work for her. The parties agreed that she was going to be a stay-at-home mom. That's what she's been doing. The younger child is in a half-day kindergarten, and so she's home with her the whole rest of the time. She has no objection to getting a job. She doesn't have a huge earning
She
capacity.
got a
but
job,
she's
she'll
okay
pay
with that.
$1,000 a month in daycare.
Yeah, and to be honest,
She got a job, make $1,000 a month, she's going to pay $1,000 in daycare, so
exactly, and she'd rather be with her kid instead of having to pay daycare and go to a job. So, she would, certainly she's willing to do whatever you want her to do. She's not saying she can't work or whatever, but she certainly, it doesn't seem to make financial sense.
the youngest one
Right
will
now.
be full-time first grade though next fall.
Yes, and certainly then that opens her up a lot more. So she's willing to do whatever you need to
Who
do. but
used
she
to
doesn't
watch
really have
them
a lot of
when
capacity.
the parents needed a babysitter?
As far as the child support.
Oh, no, who would be their backup daycare? If she had to go to work,
I don't think
or
she has any backup
if she
daycare,
needs,
right?
nobody's
She doesn't
ever...
have a lot of contacts here in town. She was kept pretty isolated.
So she's with the kids all the time, except those every other weekends?
Yes.
There's a person
Yes, she
I
is.
trust that I leave him with when I have to come to court. There's a person I
Okay, yeah,
trust.
right. It's a friend of yours?
Yeah.
Does Dad know who this friend is?
I used to babysit when
What's
we
her
used
name?
to go, Uni.
Ione?
Uni.
Uni?
Yes.
Okay, and you just call her up when you need her?
Uni's a high school student, Dar. She probably would be in school right now.
I asked her for permission. I asked her mom for permission, and if she doesn't have tests or anything like that, she can babysit. But when
Yeah.
she does,
Give you a break?
yeah, when she does, then the mom babysits.
Okay.
She's okay with going to FMC as long as they do the domestic violence
Separate rooms,
protocol.
they'll be in separate rooms.
Yeah, so to work out we've been trying to work out a holiday schedule, so if they can get that worked out and
Least,
more,
yeah.
that'd be great. He says he's made the $100 a month child support payment since August. In fact, as of the date of the deposition, he hadn't paid a single penny. His attorney did advise him, and he made one payment then, and he made one payment yesterday. So he's made $1,600 in those two payments.
Over how many months?
In order to look better. So there were two payments, one in November and one yesterday. But that's only the $100 a month minimum, which I think is kind of ridiculous considering his at least
That's
income potential
$1,600.
total paid from August to now.
August, September, October,
Yeah, he made
November,
a
December.
$1,000 payment at the end of November, whenever the deposition, no, that was in December, the depositions, I'm sorry, last month, and then $600 yesterday. Her FDF, where she lists what her expenses are, when she came to me, she never managed any of the money, had no idea what any of the bills were, had no clue whatsoever. So the expenses on her FDF, as far as household expenses, were a lot of guesswork as to what they should be. And she's not even paying them now, so she still doesn't have a very accurate idea of what those are. But they're more of a what it should reasonably cost for someone in her situation to have to live on her own. So that's what the FDF numbers are. As far as the attorney's fees, to date for me, I've been paid $17,000, and that's from her retirement and credit cards so far. And I have she owes about $6,000 to my office, plus costs for all these bank records. I had one bank, U.S. Bank, charged me over $1,000 for the records that I got from them. I got in several banker's boxes, I think from Wells Fargo the other day as well. There's an enormous amount of bank records. He has all of these business accounts and personal accounts. There's tons and tons of records, tons and tons of accounts, and those are not only is it going to cost time for me to go through, but actually the actual cost for having obtained those, because he didn't provide them to me directly, is pretty significant. One other order too, and I'd hoped we'd been able to work this out, but right now the current order is that they switch the vehicle. They have two vehicles. One is kid-friendly and
You're
one's
supposed to
not.
switch the exchanges.
And that just causes so many problems to have them switching the
What
vehicles.
kind of cars are they? I saw Judge Tootin's
They're
order.
both older. What we had discussed him paying the money for her to get a new vehicle comparable to that one that they're using right now.
What are the cars, though? What are they?
It is a
Toyota four-wheel drive. It's a Toyota.
Pickup truck or
yeah,
SUV?
Forerunner?
Forerunner.
Toyota 4Runner. It's older.
4Runner.
Yeah, it's older.
And the other car is a,
2007 Ford Ranger, Your Honor?
that's a two-seater, isn't it?
Correct.
Not even a
And he
crew
was
cab
wanting-
or king cab.
I believe he was wanting to keep both vehicles, and we were discussing him paying the money for her to buy another one comparable to the 4Runner. And so I'd asked for an order today that he give her the money sufficient to purchase a replacement for the 4Runner, so they don't have to switch this vehicle back and
Have you
forth.
searched for used cars?
Just the value, whatever the value of that 4Runner is, go in and
What year is it?
99, Your Honor.
99.
$3,500 to $4,000, Your Honor.
Yeah, she's not
Respectfully.
asking for a lot, but something. Her own vehicle, she doesn't
Man,
have to trade
she'll
off
take
with.
that money and go to CarMax or something and get a
Yeah.
minivan or something.
She can get the money, she'll just go do it. Then I just wanted to, there was some note of an email about, and I just wanted to read one line from an email that he sent to her on November 30th. I strongly suggest you start considering how you're going to pay all your bills going forward, because I cannot pay them since I don't have any income and you want a war. I'm going to ask for alimony from you when you are ordered to get a job. That's the kind of communication things that he communicates to her, and that one we have at least in writing. So I think that's it.
This is what we're going to do. Number one, as far as the TPO, we still have the pending DV case. We need to get a update on that resolution, hopefully, see what happens with that. But I'm going to keep we don't, in temporary proceedings, I don't extend TPOs unless it's some kind of rare occasion. So I normally typically continue them until we get to an actual trial on it and we hear from both sides. So I'm going to continue this. we're going to come back in 90 days as far as the mediation. If there isn't any incident, we'll probably just go back, we'll go to a mutual behavior order and restraining order. So we'll be out of the police computer system, we'll take the TPO if the things have calmed down and there's no more further incident. But I plan on continuing this at least until the return of the mediation, and then reconsider possibly to a mutual stay-away order. So this will be TPO is continued, and we'll have a return hearing, and I'll have my clerk fill out the return hearing for 90 days. Parties are referred to mediation. Obviously, we're just going to remain joint legal, temporary, primary to mom with the DV case pending. And we'll combine counsel, and I'm really speeding it up, so we'll probably combine a calendar call when we come back in mediation. We need continue with aggressive discovery. Some of that discovery will be a full accounting of the 70K, or if it's down to 38K, a full accounting of that, number one. Number two, Ms. McFarling knows what to do with giving copies of those bank records, any of that discovery. We can make it accessible. I know it costs you $1,000, but if Mr. Knoll wanted to make copies of it, should be at his cost.
I put them on disc already. He has them all.
Oh, it's all on disc. That's great. Child support. I'm going to base it off a 3,000 draw, so $750, not the $2,000 that you're asking for. As a typical solo practitioner, we're going to make that assumption, but until we have the profit and loss statements or actual hardcore numbers, we can certainly make that retroactive modification or any adjustments upward or downward. So $750 will be the child support. That's 25% of the 3,000 draw. The parties together will mutually try and figure out what health insurance the children need. Right now, they go, you got to pay both of you out of pocket, and we need to get hard numbers next time as far as an insurance policy for the children only.
Your Honor, I could address that if you'd allow me.
Real quick on how you plan on getting insurance for the kids.
Well, Your Honor, I had insurance until I couldn't afford to pay for it.
Self-employed policy?
Right, it was $635 a month, and it covered my wife, myself, and the 2 kids, but I just...
That was actually a pretty good price.
It had a
Usually it's over
$5,000
$1,000.
deductible, so...
Yeah. Well, if you need to come up with a number, see if you can just even get some major medical for the kids. They need to be covered. But we will put the task on both of you to come up with policies, and you give me a policy and a breakdown of the costs, and maybe I'll pick one. Okay, so the kids right now are uninsured. Both parents come up with a plan as far as how much policies for major medical or dental or vision will be for the kids. As far as temporary spousal support, I find that this is need versus ability to pay. It's highly questionable right now. We haven't nailed down what Dad's actual income stream is. I need to actually have more time to see what it is, but you actually also need a forensic expert to maybe figure that out. But right now, Dad will continue to pay all household bills. What's up with the internet bill, Ms. McFarling? He says he's not getting it, and it's under his name. I find it hard to... You can't call CenturyLink, it's under your name. You call and demand that information from them, or pick it up online, set up an online
I just think my client doesn't know who to call. I will get with opposing counsel to
If you
get a
do
bill.
the fast internet, it's like $49.99 a month, but you get discounts off of that. The cheapest would be maybe $29.99 a month.
She said that they had communications about the bill. And
Is it on auto debit?
For it.
Is the bills coming to the house?
The bill does come to the house. If it's in his name, he can switch it to his address. He can set it up online.
Why hasn't she been forwarding if she wanted it paid?
But she has communicated with him and asked him to pay it, and he said he didn't want to pay it. He only wanted to pay the necessary bills. That's the problem. But because these kids
And how much is it a month?
homework that's online, she really needs to
How
pay
much is it a month?
I'm not sure. Our mail hasn't, we haven't
I'm
been-
assuming it's $29.99 for the slow version, so I'm going to have Dad pay for that, being the wage earner right now. If the bills come to Mom, they should be on Wizard. Upload everything on Wizard and send it to him. Then we won't have he said, she said about who's getting what and who's sending who what. So they're going to go on Wizard, $99 a year, and that way we know if you're going into the website and actually uploading bills or paying bills. Any medical bills for the kids, you upload it on that website. Any questions you have, you want him to respond back, and vice versa. You send it through the Wizard. You email each other through the Wizard. Okay, so No more he said, she said on that kind of stuff. We'll have a 50-50, 30-30 rule on the health insurance. Constructive child support arrears are obviously going to be a trial issue. He'll pay the $750 by the last day of each month. No, we could do the 15th and the last day of each month, because Mom needs to budget and needs that money for the kids. As far as a stipend for Mom for food and gas, we're going to do $150 a week. That's less than $1,000 that she asked. $150 a week should be able to get some groceries and gas for now.
Right, I'm sorry.
So $750 a month for child support, and then $150 a week for a allowance, food gas allowance for Mom. Okay.
Is that also subject to retroactive?
Yes, this is all temporary without prejudice. We don't know what the numbers are going to be. She could get more, or she may get less. Temporary exclusive possession of the marital residence would remain in Mom. You're looking at getting the trial in August. That's how far we out on full days, right?
Yes.
So we need Dad to get a 6-month lease on an apartment. He's asking for more time. I have no problem with giving him every weekend. You go every weekend, you're buying a hotel, you might as well just get a 6-month apartment somewhere, a 6-month lease. I'll tell you what, you can have the every weekend pick up from school and drop off at school so the parents don't have to come into contact with each other. It would be Friday at 3 and Monday at 9 if they're not in school. And then you do the regular
I'm
exchanges.
sorry, Your Honor, I was writing one more time on the specific
Yeah.
dad visitation.
I'm not giving you the extra time until he produces a 6-month lease to Mom that he's got a place for the kids to stay and pictures that they have appropriate beds,
And when he does that?
clothes, and toys.
And when he does
When
that?
he does that?
Yes.
Yes.
For,
He'll get it done.
His visitation will be what when he does that?
Every weekend?
Every weekend, thank you.
The current order, he also has Wednesdays. I'm assuming that'll go away with him having every weekend.
Does he have time every Wednesdays?
It's the evening, date night thing. My client would like to, again, this case is a custody battle. My client wants to keep as much visitation as he can.
I think that would push him into...
They are 6 and 7, right? They're young. If he can do maybe 2 Wednesdays a month, every other? First and third Wednesdays of every month. So I'll cut that in half.
And can she have one weekend a month? Because these kids are in school. It doesn't
Yes,
give her
but
a
you'll
lot
have
of
to trade it with
quality
him
time.
then he'll have a Thursday night to, a Wednesday night to Friday night before the weekend that she declares. She may not want to, but if she does, she'll have to trade him a Wednesday night to Friday night, the weekend before she takes her weekend. Let's do, you want 7 or 14 days advance written notice?
7 days advance written notice from her to him this weekend?
To take her weekend.
7 days advance?
7 days advance notice in writing, uploaded on Wizard. She wants to take a weekend with the kids. Go out of town or take them somewhere. It's fine. But then if she's going to take that weekend, he will have the Wednesday after school till Friday morning drop to school. Okay? It'll be Wednesday at 3 and Friday at 9 if they're not in school. More holidays coming up by the time we come back in March or April. Any birthdays? Anything we should know about? Holidays, President's Day, Martin Luther King. Council can just share those holidays out in the hallway and figure it out?
Can we just do your default schedule for your department?
We could. I'll hand it to you guys right now.
Thank you.
Okay. Exclusive possession. So Dad will get a residence for 6-month lease. He can go month to month on that until we get to trial in August. Assign the date now. It's our CMC today, too. Calendar call will be combined in the return, and then trial will be full day for everything, right? Or you want to do custody first? You might have to do just custody first.
I wouldn't mind having them split.
I believe that would be appropriate, Your
Do
Honor.
custody first, and we'll figure out next time we meet about a property and debt trial. I'm highly interested in maybe sending these guys out for private mediation with a private mediator after we come back on the return on the custody and the mediation. That's for the property debts, alimony issues.
Okay, the return on mediation and calendar call will be April 17th at 10:30 a.m. Trial stock number 1, well, like I said, if we're doing custody, this is the evidentiary hearing. Stock number 1, August 15th at 9:30.
Is that
Parties,
full day?
TPO is
9:30.
continued, not extended, continued in effect till the return date. Parties may communicate on Family Wizard on children issues only. That's all going to be documented. Expert fees, business evaluation fees, additional attorney's fees, we will award the silver bars, the 8 of them to Mom. They're about $3,000 apiece, and I suggest she be frugal about utilizing those fees, but she may cash them in as far as this litigation. This is a case where everything's in place, the kitchen sink, a business, exclusive possession, custody. 24,000 is a drop in the bucket, what this type of case kind of commands in terms of attorney's fees. So this is not going to be sufficient, I know that, but we will award that to Mom, but she used them wisely. Instead of going full-blown evaluation on, like with Nicolatas or a business or an income stream, you go with preliminary fees, preliminary reports on that before you go for the full-blown, because that might assist in maybe trying to help with settlement. It's going to be expensive. It's going to be expensive.
Question about that, Your Honor?
No, I'm not touching the 38. If he needs to use that to utilize, it's his separate property, but obviously everything's under the watch of the court. So if he needs to do that to continue to pay your retainer, Mr. Nold, he may apply that as long as your fees are reasonable.
Understand.
Okay.
Question about the silver bars. Again, we would request, we understand we're not challenging the court's order and authority to do that. We'd request, though, that
I know that
it
they
would be subject to set off if we can show that Mr. Donohue
Oh, yeah,
was-
everything's without prejudice.
Okay, so in other
Right.
words, if he shows he's lost money for 2 years, this can't be a sergeant case, then he gets
Yeah.
a set-off for those silver
Yeah.
bars for one half.
Oh,
of it.
yeah.
That's all
Everything
we're
would fall
asking
into
for.
place, I'm
Thank
pretty
you.
sure. It'd go with credibility at trial, what kind of positions you're taking at trial.
I'm sorry, one
Right.
other point. There was 10 silver bars, council has 8.
Oh.
We'll need the serial numbers on those so we can report the other 2 as stolen.
No, I have the information on that. My client says that those 2 were sold prior to their separation and that he is
You have the
fully
receipt?
aware of it.
You have the receipt for that? Who was it sold to? A Golden Coin Shop?
Yeah, I have one receipt for one, but the other one I didn't ask the receipt. He had given me those 5.
The lawyers know what to do in terms of what they need
We'll
with
do
that.
discovery on that, Your Honor.
Now, the other option I would have, I don't know, I mean, you are, I don't know if you collect gold or silver, but they obviously, they retain their value rather than fluctuate. If you want to buy it from her, they want to sell it at $3,000 a piece to you, and then you could figure out what you want to do with those. If you really want to hang on to them, I would give you that option, but give you a deadline for that.
If that is viable, we will contact counsel and we'll deal with it ourselves.
Let
Thank
me
you,
know.
Judge.
You need to maybe investigate values.
As far as the,
Now, as far as the expert fees, I recommend that you guys stipulate to one. It would be, if you stipulate, then they are court-appointed, so they don't work for either side, and they just submit that report. You can always challenge their report or stipulate that it come into trial as a baseline.
Understand.
You going to give names? She gave Nicolatas and Teichner. The other guy is Zerga. He does forensic accounting. Joe Zerga.
We're not in a position to do that. I will work that out with counsel and get the names and try to work it out
You
with
want to do
that.
3 names to Ms. McFarling, or she's got 2 names already to you, though?
I'll be honest with you, I have not discussed this with my client. It catches me
Council
on
will
the-
stipulate in 1 week who the experts are going to be. Business eval, forensic, and income stream. Remember, there's 2 types of reports. One is the value of the business, the other one is what kind of income stream he generates. Believe me, I had a big fight in another case about that dispute. So those silver bars then will be either, you pay cash for them, or you will, after deadline, let's say by 2 weeks from now, then you have authority to sell them, to put in your trust account, to use for fees, evaluation, and all that. This DV issue, I can send them to the cheap part, which sends them to options to do DV assessments and come back in 90 days and see if that provides any kind of insight or shed some light on it. But the other one, the next step up, is a brief focus assessment with a PhD like Dr. Lankite or Dr. Puglini or Dr. Holland. They can run about $1,500 to $2,500. That's just to focus on domestic violence on one parent, maybe accusing the other parent, or you do a $5,000 to $10,000 full-blown custody evaluation. I'll hold off because we're going to mediation right now. but we would need to make an immediate decision 90 days from now because trial is going to be coming up in August. Parties stipulate that Jamie Clark will have a no contact order between her and the minor children. Mom, do the swamp cooler and leave the house for an hour? She don't trust
She
him.
would prefer him not come on the property at all. I think it just, in the abundance of caution, would be best.
If this
to
thing
not have
breaks
him on.
down, though, it's going to upset her household.
If
temporarily, I
she
guess,
can get some
while she is-
repairmen in to do it, she's happy to do that.
Okay. Just keep, then it'll be on her dime, but keep track of the receipt. We'll figure out if that's part of like a house improvement or maintenance. We'll get a status update, return on the criminal case and the Jamie Clark case. Says she's got 2 cases. The silver bars too. If you can get a used car financed, you may use some of the silver bars money to get a used car. Something kid-friendly, maybe like a Prius or a minivan. The car that she has now, is she going to turn it over to him so he'll pay insurance and she'll have to get her own car insurance?
That's what we were asking for. If he wants to keep both vehicles, and we had discussed this.
Technically, he
in his
doesn't need 2
proposal.
vehicles. He should keep the 4Runner, because that can transport kids, and sell the Ranger to CarMax and
And I believe they're both community property, so I
split the cost of the Ranger.
exactly, either if he wants to sell it and split it, or if he
At
wants
that.
to just pay for
It's
their
pretty
full-
straightforward. Once she gets her car from CarMax or
Understand,
wherever.
and then, of course, we would advertise, the Ranger's not worth much, Your Honor. I mean, it is a 2007, but it does have
It's
some
an
damage on
07.
it.
See what CarMax will pay out for
Yeah,
it.
absolutely.
I wasn't clear about, go get a 6-month lease, I'm sure you can get that. He'll qualify for that and get, as soon as you're,
Or the alternative month-to-month, like the court recommended.
yeah, he'll get that done forthwith, but he can go do his every weekend.
I'm sure he'll be on
Okay.
that today, Your Honor.
Maybe the first 2 weekends he's going into a hotel, but he should be moved to an apartment by then and set up. It's his prerogative. Did I say accounting on the 70K, 38K?
Yes.
Okay. Should do it. Oh, Miss McFarland, you're going to get the order from today. Mr. Knoll's going to sign off. He'll get the next one. See you in April.
Thank you, Your Honor. Have a
Cope
pleasant
class, they can
day.
do it live or do it online.
For the-
Cope class.
Thank you.
Your Honor, since you're out to August on trials, could we lock in a trial date on financials just in case?
Property and debts,
Yeah.
right away or a month later? Or 2 weeks later, or what?
I mean, it could be at the same time frame.
Preference,
I just
Mr.
don't
Knoll?
wanna be out.
No, court's
Same
discretion.
week?
Whatever's more convenient for the court. I know you guys have a busy schedule.
It's a Thursday, right? Is the following Thursday available, or 2 Thursdays away?
The next one's August 22nd.
1 week?
I want to save those because we get those school emergency motions around that time, a month out. September, hopefully, maybe they go to a private mediator and settle the whole case. We won't have senior judge settlement after April. And we're all booked already, so.
How about September 19th at 1:30? I mean, 9:30. I'm sorry. September 19th at 9:30.
This is a good case, though, for private mediation.
That's for the trial, step number 1.
Okay. Thank you. Got to get to my
Your Honor,
10:30s.
have a pleasant day.
Thank
You too, thanks.